My dear friends, today I am taking fourth question of K5001. Question is, what do you mean by foreign judgment and circumstances in which foreign judgments are not binding? So I am taking the definition of foreign judgment. Foreign judgment means a judgment of a foreign court, and foreign court means a court situated outside India and not established or continued by the central government. Thus, a foreign judgment means adjudication by a foreign court upon a matter before it. This is the definition of foreign judgment. And object and nature of this judgment is second part. According to S13, a foreign judgment is conclusive and will operate as res judicata between the parties. According to decay, that a foreign judgment is conclusive as to a matter adjudicated upon and cannot be impeached for error either of fact or of law. Here, my dear friends, I want to explain this nature and object. The doctrine of res judicata under section 11 is applicable in India in all suits of India. Those suits which satisfy the conditions of this doctrine. And for foreign judgment, section under 13 is applicable. Doctrine is same, the conditions are same, but section 13 is applied for foreign judgment and section 11 is applied in Indian judgments or Indian cases. So this is the nature and objects of this foreign judgment. Here S13 is more important in this nature and scope of this foreign judgment. So I am taking circumstances in which foreign judgments are not binding. My dear friends, I am taking circumstances in which foreign judgments are not binding. I am taking one by one. First, foreign judgments not by competent court. Foreign judgment not by competent court. It is a fundamental principle of law that the judgment passed by the court, which has no jurisdiction, is null and void. Thus, a judgment of a foreign court to be conclusive between the parties must be a judgment by a court of competent jurisdiction. My dear friends, this condition is also in our first question, doctrine of res judicata. In that condition, I have mentioned in former case and in subsequent case, the court must be competent in both the cases. This is the condition here. So this is the condition of competent court. Competent court should be in former case and in subsequent case. And in this foreign judgment given by the foreign court must be by the competent court. If any judgment is given by a court which is not competent or out of its jurisdiction, that judgment is null and void. This is the same case as I have mentioned in the doctrine of res judicata in question number 1. Second condition, foreign judgment not on merits. In order to operate res judicata, a foreign judgment must have been given on merits of the case. A judgment is said to have been given on merits when, after taking evidence and after applying his mind and after finding the truth and falsity of the case, judge decide the case in one way or the other. This condition is also was in our first question. The case should be decided on merit basis. The case must be decided on merit basis. So here this is also a condition. Case of the foreign court must also be decided on the merit basis. This is the condition of the merit base. So my dear friends, first condition, foreign judgment not by competent court. सेकंड फॉर जजमेंट नॉट ऑन मेरिट्स, ये भी ऐसा ऐसे केसेस हैं इस तरह के, वो नॉट एप्लीकेबल, नॉट बाइंडिंग. So these are the first and second two circumstances on which the judgments are not binding. My dear friends, I am taking third condition. What is third condition? Foreign judgment against international law or the Indian law. If any judgment against the international law or Indian law will not be binding or not is not binding, any judgment. So a judgment based upon an incorrect view of international law. Here you see incorrect view of international law or refusal to recognize law of India where such law is applicable is not conclusive. But the mistake must be apparent on the face of proceedings. Here, my dear friends, I am giving you an example. When a contract is made by parties in India and a suit is filed in England and the decision was given according to the England law of contract, that decision was against the Indian law because contract was made in India. The law should be of India, must be of India, but they applied the law of England, and such type of judgments are not binding. Fourth, foreign judgment opposed to the natural justice. Any judgment which opposes the natural justice are also not binding. It is the essence of a judgment of foreign court that it must be obtained after due observance of the judicial process. The court regarding the judgment must observe the minimum requirement of the natural justice. A judgment which is a result of bias is not binding. My dear friends, in fourth condition, the judgment should be fair. The judgment should not be under bias. Bias may be from party side or bias may be from court side. If from any side this bias is used, or you can, what is bias? Favor is done in the case, that such type of judgments are not binding. So this is the fourth condition. This is against the natural justice. Natural justice replies the fair justice according to the truth justice is given. That is the natural justice. In justice, if any type of bias is used, that judgment is not according to the natural justice. Hence, my dear student, this is the fourth condition. My dear friends, fifth condition. What is fifth condition? Foreign judgment obtained by fraud. It is a well established principle of private international law that if a foreign judgment is obtained by fraud, it will not operate as res judicata under section 30. The fraud may be either from the party side or from court side. The judgment is invalid. And here, my dear friends, I want to tell you this fifth foreign judgment obtained by fraud. This it seems clearly if in any case or in any judgment, if there is a fraud, that judgment is not applicable in India or under doctrine of res judicata section 13 is also not applicable in all the states or in India as well as. So such type of cases in which fraud is done on any part of either party or the court, that judgment is not applicable under the doctrine of res judicata under section 13 in India as well as other states. Sixth condition, foreign judgment founded on breach of Indian law. Here you see any judgment, any foreign judgment founded on breach of Indian law, if it means any judgment which is given against Indian law is not applicable in India under the condition of res judicata. Where a foreign judgment is founded on breach of any law in force in India, it would not be enforced in India. The rules of private international law cannot be adopted mechanically and blindly. My dear friends, rules of private international law must be applied as given in the rules, or Indian law also should be in the same phase as it is in the India. So, breach of any Indian law or breach of any international law cannot be adopted mechanically and blindly, and such type of judgment will not be applicable in India. So, my dear friends, I have discussed with you six circumstances in which foreign judgments are not binding. There are six circumstances. I have given one by one, and if these circumstances are found anywhere, that judgment is not binding in India as well as in other states. So, my dear students, this is the fourth question in which the definition of foreign judgment and circumstances in which the foreign judgments are not binding. I have made this concept clear to you. So, I think you will feel or you will get help from this question. So, In the last, my dear friends, I want to make a request to you. Please subscribe the channel. I shall be very thankful to you.